Please read.
The Little Falls Township Planning Board meeting of Thursday, June 5th, 2025 is called to order. Please take notice that adequate notice of this meeting was provided in accordance with NJSA 10:4-8 and NJSA 10:4-10 as follows. Notice of the meeting was promptly posted on the bulletin board at the municipal building located at 225 Main Street, Little Falls, New Jersey on January 9th, 2025. Copy of the notice was sent via email to the North Jersey Herald and News on same date. Additionally, a copy of the notice was filed in the office of the Township Clerk. Please note that this meeting is being taped, therefore we ask that you speak loud and clear into the microphones.
Thank you. Please call the roll.
Mr. Barry,
Here.
Mr. Karaj,
Here.
Mr. Luke Damiano,
Here.
Ms. Cataldo,
Here.
Mr. Seaver,
Here.
Mr. Poshis,
Here.
Mayor Damiano,
Here.
Councilman Scoba,
Here.
Dr. Abdi, Mr. Wade, Mr. Dolan,
Here.
Mr. Rema,
Here.
Mr. Brigliadoro,
Here.
Mr. Koblars,
Here.
Mr. Barry, Mr. Kilpatrick.
Here. Do we have any comments from the council?
Chairman, no one came before the governing body at our last council meeting.
Thank you very much. May I have a motion for the approval of the very quick meeting of May 1st, 2025?
Make a motion.
Second.
Tyler?
Mr. Barry,
Yes.
Mr. Karas,
Yes.
Ms. Cataldo,
Yes.
Mr. Seaver,
Yes.
Dr. Abdi. Yes. Ms. Zarema,
Yes.
Mr. Kilpatrick.
Yes. Minutes are approved. There are no resolutions to memorialize. Does anybody see Mr. Vettery?
Chairman, you want me to go?
Please. While we're waiting, I do have an announcement. There will not be a meeting of the planning board on July 3rd, 2025, as it is the day before 4th of July holiday. Welcome.
Hello, welcome. Hi, everyone. Good evening. Entering my appearance for the record on behalf of Zen Real Estate LLC, John Vettery, 3 University Plaza, Suite 207, Hackensack, New Jersey. I regret to inform you, we're going to make this an early night because we've been having some discussions with the professionals with regard to an issue pertaining to access to the site. So, Mr. Chairman, if you allow me a little bit of time just to explain that, and we're going to respectfully request an adjournment to come back after having the ability to potentially look at some access issues from this site. So let me just give a little bit of, we are on the record, and Mr. Brigliadoro would confirm because there were some questions from members of the public with respect to notice that we have adequately noticed. We presented you certified mail slips.
Mr. Chairman, Mr. Vettery did provide me with proof of notice of the application. I did review it, and it does conform to all the requirements of the municipal land use law, so that the board does have jurisdiction to proceed with this hearing.
Thank you. And I understand from members of the public that sometimes these letters either don't get to, we have no control over it. We did actually send them a little bit early so that everyone could get notice, and it was put in the newspaper as well, which is now online also. So just to give a little summary. So this is a site. It was vacant land for many years. It was built in 1964, 1965, I believe by Abeta paper tube company. Some of you remember the Abet A sign, maybe not. And at that time, this property was 75 Harrison. It had an access from Harrison, and it wasn't until later that there was a negotiation of an easement to go through Sindel. through the property that's at 53 Sindel, and we can show this next time on the map. So there's an easement. There are two private parties. This property always had access from 75 Harrison, and that access was then verified and acknowledged in 2005 when this board approved an addition to the building. So there was a 16,500 square foot addition that was approved by this board back in 2005. Mr. Chairman, you were the only member of the board that's still here that voted on that. It was a unanimous vote, and it allowed for a loading zone on the Harrison Avenue side, and the addition wrapped the building. It acknowledged the only variance that we were seeking this evening, which was to allow a buffer between the residential neighborhood and this lot in terms of parking. And so on the Harrison side, it's fine. It's more than 40 feet. It's the area by the field, even though the field is used as a field of municipal purpose, it is actually in the R1B zone, so it necessitated that. But when it was built, the parking was there, and then that was verified and acknowledged back in the 2005 approvals. And I believe that those resolutions were submitted along with our application. Okay, now fast forward to 2024, applicant came before this board with a plan, and that plan called for something that's very high in demand, which was a 40-foot ceiling. Anyone that knows the warehousing business, that's something that's very important for a warehouse building to have that ceiling height at 40 feet, whereas only 30 feet is allowable in the zone. That application was denied. It was a D6 variance. I didn't handle that application. I believe it was bifurcated to do the D variance first, and then they were going to proceed with the preliminary and final site plan. Never got that far because the D6 variance was denied. So now fast forward to 2025 and what we're doing tonight. So the application tonight was essentially just for a preliminary and final site plan approval, going back to the 2005 approvals, but shrinking it and moving the loadings, keeping the loading zone where they are, away from the residential neighborhood. The 05 approval had it on that side. During the discussions at the last meeting, it looks like from the minutes, there was some discussion about access. And I completely appreciate from the perspective of the neighbors that access is an issue. Access on Harrison Avenue is an issue, and I acknowledge and respect that. And I also acknowledge that people on the other side, because I've heard from them as well, people on Sindel Avenue, people on Van Ness, believe that there's a fair sharing by allowing the access from both. So where are we right now? We have a dispute, frankly, with the neighbor that owns 53 Sindel Avenue. That dispute has to do with this very easement, because the owner of that building is saying it was never intended that 100% of the traffic go through my property. He owns that property. This applicant does not own that property. It's subject to an easement. It's unclear whether it would survive litigation to say that 100% of the traffic should now go through his property. That's 100% of, use, snow plowing, use, trucks going through there. It's 100% going through Sindel Avenue. To further complicate things, they have loading zones in their building. So when their 53-foot trailers pull up to their building, it's a right that they have. You can't get in. So that causes someone trying to come in from Sindel Avenue having to wait and idle in the parking area and not being able to get through. So we've had some discussions with the professionals. We're going to see if we can, and this is the reason we're requesting this adjournment. We're going to see if we can negotiate with this property owner. They have their legal rights. This property owner has his legal rights, but we're going to make an attempt. And I appreciate everything from Mr. Copolars, the planner, Mr. Brigliadoro, and I'm going to share, and I don't know if I've shared these easement agreements with you. I'll do that so that you can see them. You can't sleep tonight, members of the board. I will definitely share them with you as well. They're a little arcane, going back to the 60s, but we're going to have to see. So we'll make an attempt to see if there's something that we can do, but we have to understand that there are property owners here that have rights. And it may be that we, the township, or even if the applicant wanted to, doesn't have the right to mandate to an owner of a private building to say, we're going to use Sindel, your property, albeit there's an easement that goes through it, but we're going to use that 100% of the time, and we're going to close off 75. That's the crux of what we're going to attempt to do. From a legal perspective, it's essentially a preliminary and final site plan application we're asking for there. The only variance is a request for a variance that under the code in Little Falls, under section 28099, there's a code that says you have to have a 40-foot buffer from the residential neighborhood. And this property never had that. So as you know, like where the field is, where the new fencing is, where the turf field was put in, the parking is maybe, I think, 11 feet from that area, but that's a pre-existing condition. And it was also acknowledged and affirmed in the 2005 approval. So there's some debate as to whether there's even a legal requirement to ask this board for that again, but to err on the side of conservatism, we asked for it. So that's a summary of what we're trying to do. We're going to be as transparent as possible with everyone. That's what we're attempting to do. I'm not sure we'll be able to accomplish it, to be honest with you, but we'll make an attempt and we'll report back to the board. We'll share everything with you. I thought perhaps this evening we might be met by the attorney and the owner of 53 Sindel. I don't see them here this evening, but so stay tuned. And I'm here and our professionals are here if anyone has any preliminary questions, and then we'll report back.
Just one item. I'm not sure if you were in the room. We have canceled the meeting of July 3rd.
I kind of figured as much. Having been here for a few years. Okay, so then we'll have more than enough time to take a look at this and report back at the August meeting.
Thank you.
Thank you, Mr. Chairman. Thank you, members of the board.
Chairman,
Yes.
you want to carry this without further notice to the public?
I don't think we have an option. Yes.
So just for members of, so the August date, I believe, is August 7th.
I don't know.
Let me just double check.
Is it?
Val says
Yes.
it's August 7th.
I trust that.
Valerie says it's August 7th. It's August 7th.
So any member of the public that was here tonight, we're going to carry this matter, the board's hearing date on August 7th. There'll be no further notice to the public. So you should come back to this room on August 7th at 7 o'clock if you want to hear the continuation of this application.
Mr. Vetter, you want to get word to the other owners?
Sure.
Thank you.
Okay, thank you. Thank you, everyone. Sorry for the short night. I thought I had something else to do.
Apology accepted. If anyone doesn't want to stay, you can feel free to leave. We're moving on to different business. No, what you are allowed to do is to question the application's professionals after they make their presentations. There have been no presentations. So, no, sorry. Mr. Barry, do you need a moment? Are you good
No,
to go?
I'm good as long as the crowd's good.
You seem to be enjoying yourself.
No, take the
All right.
entertainment where we can get it.
Our next application is a public hearing, Township of Little Falls, fourth round housing element and fair share plan, prepared by John Barry, AICP, PP of Higher Cruel and Associates, public hearing and adoption of the housing element and fair share plan. And I can only tell you that a lot of work has gone into this over a long time. Mr. Barry,
Thank you.
can you address
Rich,
that?
you sworn?
Yes.
Yes.
You swear. You swear from the testimony that you're about to get before this board is going to be the truth, the whole truth, and nothing but the truth.
I do.
Obviously, we know who you are, but just for the record, confirm that you're the board planner and what your credentials
Sure.
are.
John Barry, professional planner licensed in New Jersey for a little over a decade and worked for the firm Higher Grove Associates and the board's planner and township's planner. So Board members, I'm gonna do the quick version. If we have questions, we can blow it out as much as we need to, but we'll start small and see where we end up. The document that's been on file for the last 10 or 11 days is the township's fourth round housing element and fair share plan. It is a component of the township master plan, so it's adopted by the planning board. And basically, we have state law going back, over 50 years at this point, and most recently amended in 2024, that outlines this process where every town in the state has an obligation to plan for its fair share of affordable housing. We have a number of affordable housing units for the fourth round that was established through, and initially a number was provided by the Department of Community Affairs. We went through and reviewed that number and ended up reducing it by about 111. It went from 285 down to 174. The Township governing body adopted a resolution back in January fixing that number of 174. There was a challenge to that number by an interested party. Ultimately, we went through a process with the program that's designed to mediate or adjudicate those challenges, and the number that we established of 174 was upheld. So that's the township's obligation for the fourth round. The township, as everyone well knows, has gone through a planning process with affordable housing previously. The third round plan was very robust and put a number of different mechanisms in place to address the township's obligations at that time. All of that remains and is a solid foundation for where we are today. In looking at the 174 number, obviously there's very little developable land left in the township, especially considering the changes to the flood hazard regulations that have come about. We're familiar with that with the application on Main Street that was approved and then was ultimately unable to get its permitting from DEP to construct residential. So the number of areas in the town where residential development can be built has shrunk over, especially since the third round plan with the changes to those regulations. So we did a vacant land assessment, which is part of the process for planning for affordable housing. We identified basically one area in town, one parcel that has changed circumstances from the third round. Obviously, there's other things that have happened. Things have been built, torn down, rebuilt. But most notably at the corner of Main Street and Stevens, there was a gas station for many years, and that was demolished. And now you have a vacant piece of property that's certainly developable and is zoned for development that could accommodate multifamily residential. So we identified a realistic development potential of 3 units based on the availability of that property. So with that, we have our 174 top line number. Say, well, realistically, we have land for 3. So the unmet need is what it's called is the remainder, that 171 after we subtract our realistic 3 from that top line obligation of 174. So how do we satisfy our obligation, keep everybody happy and out of trouble? The 3 units that are anticipated through this process for that Main Street and Stevens property, they essentially take care of themselves. It's zoned for multifamily residential development now, can be expected to generate those units if somebody comes in with an application to the board. So in terms of planning for it, we say, well, here's land, this is what it can produce, and we've got zoning in place already that takes care of that. Under the more recent amendments to the Fair Housing Act, the fourth round rules that we're operating under, they say we need to identify a realistic potential or a opportunity for redevelopment that might construct 25% of that unmet need number. So we were targeting, do the math off the top of my head, I have it written down. It's 43 units is 25% of the unmet need. So in looking around, we already, in the township, already had some stuff in place that was done since the third round plan was adopted that wasn't already considered in the third round plan. The downtown redevelopment plan was put in place in, I believe it was in 2020, or more recently than that. There was also some, there's the Central Business District, the Transit Village Central Business District zone that permits multifamily development or mixed use development that includes affordable units that wasn't accounted for in the third round plan. So with those 2 areas, parts of town that have already been zoned or put into a redevelopment plan, looking at the amount of land that's available there, the relative density that is consistent with the other zones nearby, and just extrapolating out that math for how many units might be built if redevelopment takes place, we more than cover that 43. Probably looking at more like 90 to 100 units, depending on which parcels get built out. So the long and the short of it is, we have an obligation to hit. We have a realistic number that is vacant land that already has zoning in place. And then we have this unmet need that we can factor in two different areas that weren't counted in the third round. So we're not double counting. We're looking at new land and new zoning that was put in place since that third round plan. And with the potential build out of those areas, we've more than satisfied the chunk of unmet need obligation that we have an obligation to plan for. And subject to just, I think, some minor amendments to those ordinances, just to clarify the densities that are permitted, because in both cases, it's a little open-ended, how many units per acre are allowed. But honing in on that number, in the case of the Transit Village CBD district, the other Transit Village districts allow 35 units per acre. So a minor amendment to that ordinance to permit the same would take care of that. And then with the Main Street, the downtown redevelopment area, the implementing is a density in that does not have a density clarified in the plan, but we had prior to my time, but the board had the 16-50 Patterson Avenue approval, set both sides of the street, the two different approvals. We look at the densities that were approved there and basically apply a similar density to the remainder of the redevelopment area. That more than takes care of our obligation. So two minor changes may need to be implemented by the governing body to follow through. We have, under the rules, we have until March for the township to make those changes to be consistent with the timelines that are in place. But hearing and adopting the plan this evening will take care of the most pressing deadline, which is June 30th for everybody around the state to get these plans done and submitted. And then from there, there's very little left to do. We have a couple resolutions, just some housekeeping kinds of things that the governing body will need to adopt. But otherwise, hopefully, absent any pushback or challenges from parties who have not yet made themselves known, we should be in good shape, and the township's plan should be solid moving forward.
Thank you for all the hard work you put into this, Mr. Barry. Any questions to the board? You've got a professional here if you want any information on this. Very well.
Mr. Chairman.
Yes,
We should put on the record.
you
that the-
didn't give me the 1 minute to call. Go ahead.
Should indicate on the record there are no members. Here.
We're going to indicate on the record that no members of the public are present in the building. Thank you. Should I just do the motion to approve, and you'll have some comments after?
Well, the motion would be to adopt and approve the housing element and fair share plan as an amendment to the township's master plan, and also to memorialize the resolution that's been provided to the board.
May I have a motion based on what Mr. Brigliadoro has just recommended?
So moved.
May I have a second? Any discussion? Please poll the board.
Mr. Barry,
Yes.
Mr. Karas,
Yes.
Mr. Luke Demiano,
Yes.
Ms. Cataldo,
yes,
Mr. Seaver,
Yes.
Mr. Poshis,
Yes.
Mayor Damiano,
Yes.
Councilman Scoba,
Yes.
Mr. Kilpatrick.
Chairman votes yes, and announces that the application is approved and that do we need a separate resolution on memorializing?
We did it all in one vote.
Very good. Then I'll just continue on as the resolution has been memorialized. Thank you very much, everyone. Is there any old business? Any new business? Going forward, I'm recommending we drop the approval of bills because we don't get to see bills. So that must be going through our finance office. Anyone have any questions or comments? I thank all those that are attending the session from the NJPO, which is what, New Jersey,
Professional.
thank you, Planning Official Organization. We will all be trained by the end of June. May I have a motion for adjournment? Second,